Greetings to one and all. Let me begin with a parable. If there is a huge elephant heading towards east, and then there is a small ant right on top of this huge elephant, which is walking towards west, where do you think this ant will finally go? Hold that answer and that thought. We'll take a look at it after you've heard what I wish to say in this part 2 on the talk of on law of impossibility. Now, for the benefit of those who could not have an occasion to watch the part 1 of this talk on law of impossibility, I shall do a small recap. I had mentioned to you that this law of impossibility is encompassed in an ancient legal Latin maxim, which is mentioned as lex non cogit ad impossibilia. This maxim essentially means law does not compel a person to do that which cannot possibly be performed. I had also shared with you the most essential requirement for application of this maxim is that there should not be any contract between the parties which otherwise says so, and even if there is, there should be no clause with regard to force majeure. So it is in these circumstances that this maxim can be applied. Apart from this, I had also shared 3 other essential requirements to be present in order to apply this principle, and they were whether the event, that is the non-compliance, was beyond the control of a person, occurred without any fault of the person, and it resulted in an impossibility. I had also said that we'll try and see how this law of impossibility is going to work in 2 aspects. One was lease deed and lease agreements, another was employment contract. So let's now just see first how this law of impossibility operates in lease agreements. Of late, we have been seeing that there has been a lot of buzz and talk about the fact that many of us could not access our residential places, our workplaces, and then there are many people who are giving up their places. How does this was all because it was impossible for us to do something. So if all these 3 essential elements, if they were present, then how does this law operate is what constitutes today's talk. First and foremost things to be kept in mind is wherever there is a lease agreement, that is, there is a valid lease agreement, the terms and conditions of that lease agreement will govern the parties. Now, what do I mean? Example, if under the lease agreement the parties agree that the agreement becomes void or terminated on certain events, then it will happen on that event. Now, because generally we don't see any agreements where they have said if it is impossible to do this. So if only in the absence of any clause pertaining to impossibility, it is only in such situations that the law of impossibility will apply. We will have to explore this essentially by seeing how the courts have applied this principle. The first and foremost case in which this law of impossibility was argued or submitted in case of a lease deed was in the case of Raja Dhruvdev Chand versus Raja Harmohinder Singh. This is 1968 Supreme Court. The facts were a little unique again here, in the sense that there was a lease agreement and the lands which were leased after partition went into the share beyond the boundaries and the parties came within the country. So the lessee said that it's impossible for him to access the land and cultivate them, and he also asked for refund of whatever has been paid. I think one paragraph deserves to be looked at, and it is para 9. The rights of the parties did not, after the lease was granted, rest in contract. By Section 4 of the Transfer of Property Act, the chapters and sections of the Transfer of Property Act which relate to contracts are to be taken as part of Indian Contract Act 1872. That section, however, does not enact and cannot be read as enacting that the provisions of the Contract Act are to be read into the Transfer of Property Act. So we all know that law of impossibilities is rather adopted or codified under section 56 of the Indian Contract Act. Now what does the Supreme Court said? Supreme Court says here that this Indian Contract Act will not be applicable if there is a lease deed, valid lease deed between the parties. So the provisions of the lease deed, the Transfer of Property Act is to be read in Indian Contract Act. So while doing so, they said it is the Transfer of Property Act which becomes applicable for a lease deed. So therefore we'll have to now go to see what Transfer of Property Act says with regard to a lease and what are the obligations, rights and considerations etc. under that. Now lease has been defined under section 105 of the Transfer of Property Act, and it says a lease of an immovable property is a transfer of a right to enjoy such property made for a certain time, express or implied, or in perpetuity in consideration of a price paid or promised, or of money, a share of crops, service, or any other valuable thing of value to be rendered periodically or on specified occasions to the transferor for the transferee who accepts the transfer on such terms. A reading of this clause section clearly shows that three essential requirements should be there for a lease. So that should be an immovable property, and there is a transfer of a rights to enjoy this property, and this transfer should essentially mean the transfer in the manner said in section 5 of the Transfer of Property Act, and then there is a consideration in return for this enjoyment. And now this consideration can be a premium or a rent, and rent is included to mean a share in the crops, a share in the profits. Insofar as this plea of impossibility, that is the inaccessibility to the land, the Honorable Supreme Court applied section 108 capital B, that is provisions pertaining to rights and duties of obligations and rights of both lessor and lessee, and the specific provision was 108B small e, and it reads like this: if by fire, tempest or flood, or violence of an army or of a mob, or other irresistible force, any material part of the property be wholly destroyed or rendered substantially and permanently unfit for the purposes for which it was let, the lease shall, at the option of the lessee, be void. So the key words that we see here is permanently and substantially it should have been destroyed. The cause for the destruction could be many. So if we are going to make a plea of impossibility, then in cases of leases we should also show that the immovable property was permanently and substantially destroyed. It is only in such situation that law of impossibility can be applied to a lease agreement. In fact, the Honorable Supreme Court in this very case at para 17 says like this: the inability to use the premises is not or does not amount to substantially and permanently unfit. And in part 1 also I had shared with you a couple of case laws where the courts had made a distinction between inability or incapacity vis-a-vis impossibility. So if it is inability, then impossibility has no place. So in the present circumstances, if we were to apply the situation of a COVID, then I think we may have to come to the conclusion that it is the inability and not the impossibility that would play a role insofar as lease agreements are concerned. So does that mean that impossibility is not at all applicable to lease deeds? The answer, in my opinion, cannot be a complete no. So let us see a few more case laws as to how Supreme Court has applied the principles of impossibility. The next case that I want to share with you is in the 2004 Supreme Court. It is in the case of Raichur Matam Prabhakar versus Ravatmal Duggar. And here at para 9, the Honorable Supreme Court has spoken about a concept or a doctrine which is called as a suspension of rent. It says at para 10, there has developed what is known as a doctrine of suspension of rent based on principles of justice, equity and good conscience. If the lessee is dispossessed by the lessor from the leased property, the obligation of the lessee to pay rent to the lessor is suspended. Now there is a Hong Kong case that we came across in our research where the plea of impossibility was taken, and this was at the time of SARS in the year 2004-5, and this is famously called as SARS case, but it was given by a district court in Hong Kong. This is in the case of Lee Ching Wing versus Uani Xiong. I hope I pronounced that right. It's 2004 Hong Kong. Now this was a case where this person could not access his flat because it was quarantined, and the lease period was 2 years. The Honorable Court of course denied him the relief of suspension of rent, but there were two aspects that caught my attention, and I'll share with you so that you can see how you can make best of this. One is, the court said that had it been a longer period of time, in this case it was 10 days of inaccessibility, had it been a longer period of time, the period of 10 days was too short to consider for any suspension. And the most important other thing that the court looked into was, if the party could show from the lease agreement or the covenants in the lease agreement that his habitability is to be read in the covenants of the lease. So if we were to read the clauses, if we have structured our clauses in such a way that living or working or conducting business is a part and parcel of the lease, then in such circumstances the one could get the benefit of impossibility. I'll just show the words what the Hong Kong court said. It said, however, if the defendant were to succeed, he must be able to show that there was an implied term as to the habitability throughout the term of the tenancy. Okay, before I proceed, let's look at this list of Supreme Court cases where on facts there was a lease agreement. I have spoken on most of them. Now there are two more cases that I wish to share with you, and in these cases there was no lease deeds. The first situation was where a lease deed was about to come into existence, and this was in the case of Sushila Devi versus Hari Singh. This is 1971. Now the facts of this case were, I wouldn't say similar. Facts of the case were also arose during the partition. Now the uniqueness of this case was, there was an agreement to enter into a lease deed, but whereas there was no lease deed that had happened, and the court and the person, that is a lessee, after coming into India, filed a suit for recovery of whatever was paid under the agreement. And it is in such circumstances the Honorable Supreme Court made a distinction between a concluded contract and a contract, that is a lease agreement, which is yet to come into force. So in such circumstances, the Honorable Supreme Court said as under. There is a clear distinction between a completed conveyance and an executory contract, and events which discharge a contract do not invalidate a concluded transfer. Therefore, we agree with the trial court as well as the appellate court that the contract had become impossible of performance. These words, concluded contract, reminds me to also mention that this case will be very helpful. This case is seldom spoken about. This case will be very helpful where there is no concluded transfer of the property. Like for example, in auction, there's a huge time gap between the date of the auction and actual taking of possession. So heavy EMDs also will be paid. So this case will be helpful in such situations. The other situations would be cases where the lease deed has come to an end and there is no longer a landlord and tenant relationship existing. The matter could be in court, or there could be also an order of eviction, and the party could be in possession, the tenant could be in possession, and the consideration could be in the form of damages for holding on to the possession. In such cases, one would say, based on what we have so far seen, that law of impossibility could come to the rescue of a tenant. But it was answered otherwise in this just few days ago, this decision has come in the case of Ramanand. It can be popularly called as the Khan Market case by the Honorable Delhi High Court. Now, what worked there was that the tenants were not the so-called occupants. I don't think I can call them tenants now. The occupants were not willing up to give up their possession. They wanted to continue, and the court was guided by this Woodfall laws, which is also applied by the Honorable Supreme Court in Lakshmipati's case. And this law essentially says, this is in Woodfall Laws of Landlord and Tenant, 28th edition. It says, a demise must have a subject matter, either corporeal or incorporeal. If the subject matter is destroyed entirely, it is submitted that the lease comes automatically to an end, for there is no longer any demise. The mere destruction of a building on land is not total destruction of the subject matter of a lease of a land and building. So the demise continues. But if by some convulsion of nature, the very site ceases to exist by being swallowed up altogether or buried in the depths of the sea, it seems clear that any lease of the property must come to an end. Now, in this case, Ramanand's case, the citation and the entire list of all the cases that I'm talking to you about, I will put it in the end of the talk in a list format. I was saying that in this case, the Sushila Devi's case was not taken into consideration. So, and two is whether when there is no relationship of a landlord and a tenant, how far the Woodfall's principles or Woodfall's law on landlord and tenancy was also applicable is a big question mark. Nevertheless, I would hasten to add that the existence of the immovable property and the occupation of that by a party has played a huge factor in deciding all these cases. Like in that Raichur Mutt's case, the property was not in existence, and that is how the principle of suspension of rent was applied. In the end, I would like to just show one this notification from Ministry of Home Affairs. This is dated 29th March. I'll just read the way it is. These are the last 2 points in this order. Wherever the workers, including the migrants, are living in rented accommodation, the landlords of those properties shall not demand payment of rent for a period of 1 month. If any landlord is forcing laborers and students to vacate their premises, they will be liable for action under the Act. Now, what is the binding nature of these orders or notification is, I think, would form a complete topic to be spoken about. But nevertheless, this is there. And of course, the suspension of rent in this case was just for 1 month, and whether it can be extended, whether it warrants extension, is again for the concerned authorities who will take a decision in the matter. So with so far what we have seen, it looks like the courts have gone on the principle that so long as possession has been given under a lease, the obligation of the tenant to pay rents or to do such other obligation under section 108 of the Transfer of Property Act applies. It is only where the property is substantially damaged or totally unfit for using permanently. In such cases, the lease deed appears to become void. Now, if we were to take this uh, law as is laid down in various case laws into the present situation, no doubt one can conclude that it will be a, or it could be a lose and win case for tenants. But the incidents that have happened in the past few months or few weeks, uh, it is alarming to see the extent of leased area that is being surrendered. Now, whether the equation of the lose and win is there, or it has now turned into a lose lose situation for both the landlords and tenants, is a matter that really requires reflection. And therefore, it's the need of the hour to think out of the box. Now, why do I say so? The facts in both Sushila Devi's case and in Dhruvdev Chand's case happened in the year 1947. So the clarity to them came sometime in 68 and 71 respectively. And it is this is what will now take me to the parable that I started with. Yes, the ant will have to go where the elephant is heading. Now, if we were to take this huge adversarial legal system as an elephant which is going in one direction, then the poor litigant on the ant, whoever it could be, a tenant or a landlord, will have to go in the way that the adversarial justice dispensation system will go. Therefore, I think it's time now that we should make uh, efforts to put in use or best use of other forms of alternative dispute resolutions. That could be many things, from mediations to dialogues or to conciliations. Now, I'm cautiously not using the word arbitration because there are certain statutes and protected situations to tenants, like under the Rent Control Acts, where the Honorable Supreme Court has held that one of the non-arbitrable issues or disputes could be between landlord and tenants. This is in the case of Bose Allen and Hamilton Incorporated versus CBI Homes. I'll include this also in the list of case laws. However, there's no doubt that this has been referred to a larger bench for reconsideration in Vidya Drulia versus Durga Trading Corporation. So, if there are no such compulsions for referring to arbitration, then arbitration also is one such mode of alternative dispute resolutions to bring speedy disposal or speedy justice to the parties. I will leave with you section 44 of the Karnataka Rent Control Act as well, where it says that the court should promote for negotiated settlements between the parties. So before I end this talk, I sincerely thank the organizers for this opportunity.